pelvic and crotch area. This can feel a little bit like electric shocks, and it's known as lightning crotch in the birth world. So this is just your baby's head putting pressure on nerves and joints, and it can cause these shooting pains. However, it shouldn't happen all the time. If you felt constant pain in your abdomen or pelvic area, get checked out at the hospital straight away.
2020, lockdowns forced most of the courts to conduct proceedings via Zoom.
What haven't I done, bro? I done everything except go to the moon, bro.
However, many courts enacted policies banning personal recordings of the remote sessions. Some created this ban while simultaneously live streaming their hearings on YouTube.
Are you? Right, so are you. You're broadcasting under 122H.
Because rules for thee and all that. This was in fact the scenario for attorney Nick Somberg, who in May of 2020 appeared on behalf of a client via Zoom for a pre-trial hearing which was being broadcasted to YouTube by the court. Attorney Somberg took a screenshot and posted the picture to Facebook. Attorney Somberg in contempt for violating Michigan Court Rule 8.115, which bans using a portable electronic device to take pictures, video, or audio recordings in a courtroom unless allowed by the judge, in a courthouse without prior express consent of an individual, any area inside a courthouse where a proceeding takes place, or anywhere a judge conducts an event concerning a court case. This attempt to charge Attorney Somberg was quickly dismissed, and just 2 months after the attempted persecution of Somberg for daring to take a picture of a YouTube live stream from the comfort of his office, he filed a lawsuit against the Oakland County prosecuting attorney under First and 14th Amendment claims and 42 U.S.C. 1983. In the lawsuit, he asserted that he seeks to and will again exercise a right to make digital records of publicly live-streamed matters of public concern by the state judiciary, and that
In 122H coverage, we can play games. I'm not stopping.
he seeks to and will again exercise.
For not taking the videos down, because I'm not taking them down.
He now seeks to create new law. In 2022, his motion for summary judgment was denied, and now, 4 years later, the case has made its way to the United States Court. In the case,
Case number 23-1872, Nicholas Somberg versus Karen McDonald. Arguments not to exceed 15 minutes per side. Excuse me. Mr. Ellison, you may proceed for the appellant.
Thank you. Good morning. Philip Ellison appearing on behalf of the appellant. I'm reserving 3 minutes for rebuttal. Your Honors, this case is not about access, despite the appellee's attempt to try to turn this case into an access case. This case is actually under the branch of information gathering, and information gathering for further discussion on public affairs is part of and considered consistent with free speech and an expression and protection under the First Amendment for the right of expression. I'm asking this court to recognize that when the government broadcasts information publicly, that they cannot, consistent with the First Amendment, then limit or otherwise preclude the capture of that information for the purposes of rebroadcasting, reusing, speaking positively, speaking negatively, being critical, being.
What about altering?
Well, then that would go to whether it would be truthful communications. Now, when you say altering, I'm assuming you mean to alter like maybe like a deep fake type situation where they're altering it to make it look like someone said something that they didn't actually say. That would be the court statements that way. But
are you saying that they could limit the speech based on where the person recording is? In other words, if they're in the courtroom, can they limit someone from recording?
For purposes of this case, I'm drawing that distinction. Now, whether that's what I would argue as being what the court or what this.
Let me give you a hypo and explain to me how this works. So often in high-profile trials, they have an overflow room. Assume the overflow room's next door in a hotel or in a public park.
Okay.
The people in the park can record, but the people in the courtroom cannot.
It would be, and I think the answer would be yes, because the people in the park next door would not be doing anything that would be to disrupt the proceedings that are going on in the courtroom themselves.
Well, dip me in shit and roll me in breadcrumbs. So it sounds like all we have to do is disrupt the motherfucking courtroom to get a rule change, right? Yeah, that's the way that somebody would think about it if they were a fucking slimy weasel.
I have an address for you, Miss Lopez. I need you to look up at me, ma'am.
Excuse me, miss?
Lightning crotch.
You can shut the fuck up and have some respect for people, you dumb bitch. Since you want people looking at stuff, I've been looking at the ways that you guys weasel those court dates around and get people's schedules all fucked up, huh? What are you doing sitting there in front of everybody's calendar, huh? Can you look at anybody's calendar? Huh? Huh? Can you? Wouldn't that be weird if, you're just filling in, helping out, right? On a sick day, somebody's having a sick day, so you're helping out? Or really, is it because you're changing dates in there, huh? Oh, is that not possible? Is it like password protected or something? I wonder.
Initial appearances at Pima County Consolidated Justice Court breaks the fourth wall and questions court staff after noticing a discrepancy with the court dates she had just set. News for Tucson's chief investigative reporter, Corus Nylander, is live outside Pima County Justice Court downtown with more on this unusual situation.
I'm going to need you to look up at me, Rachel. Huh?
Corus, how did this controversy even come up?
Yeah, well, Sean, Judge Lisa Sergio is a Tucson City magistrate judge, but she was here at Justice Court serving as a pro tem judge, helping out with...
Is that what you're doing, Rachel? Helping out?
Initial appearances. Things were pretty routine until the public defender asked her for some clarity on a court date she had just set. Well, that's when things took an unusual turn.
As they do, Corus, my boy.
Thank you. The rule that I would clarify then, Your Honor, is he recording? And I would just like to clarify that.
For some clarity on a court date she had just set. Well, that's when things took an unusual turn.
Whoa. Wait a minute. You're changing the court dates I said?
I have.
Okay, I'm ordering you not to change the court dates that I set.
It's not every day you see conflict between a judge and court staff.
Well, Corus, that's because the judge is the court staff.
During initial appearances Wednesday night in Pima County Consolidated Justice Court, Judge Lisa Sergio had just finished seeing a defendant facing several felony charges related to drug possession. She had just set his next court dates. The public defender then asked for clarity.
Your Honor, really quickly, what was the Justice Court date?
That's when Judge Sergio learned the court staff had been ordered by supervisors to change the dates.
All right, I'm being informed for the first time on the record that the court dates that I set in Justice Court are being changed after I set them. Apparently, staff have been directed by their supervisors.
Judge Sergio then pointed out fears that some defendants may be getting arrest warrants for failing to appear at court dates they may not know were changed.
It's no big deal. Don't worry about it, man. Just court, you know what I mean? It's only like your life, bro.
The defendants are expecting to have court. They are not being informed of the court date that's being changed. They're not being informed, had no notice whatsoever.
And that type of confusion can have...
of the new court date, which means that they're probably failing to appear and getting warrants, even though they have
really potentially devastating consequences for the defendant if they miss a court date.
Louis Fidel is an experienced...
What the fuck did they just say? Hold on, back the truck up a little bit. What the fuck? First lady said that we failed at something if we don't get our court date and don't show up, and the second guy said that we should deserve consequences for that.
of the new court date, which means that they're probably failing to appear and getting warrants, even though they have
really potentially devastating consequences for the defendant if they miss a court date.
So they don't give us a court date, but we fail. It's not a failure on their part to give us the court date, and there's no consequences when they don't give us the court date, but it's devastating consequences for us and a failure to appear on our half. Fuck these motherfuckers.
Fidel is an experienced criminal attorney in Pima County. He believes if the judge is accurate about no notice being given to the defendants, this is a serious issue.
You know how when you start talking, the judge will cut you off? Well, I'm going to go back and play this guy what he just said, and I'm not going to alter what he says. I'm just going to cut him off at the right moment, okay?
Devastating consequences for the defendant if they miss a court date.
Louis Fidel is an experienced criminal.
There we go, an experienced criminal. That's more correct. So she thinks not giving notice of a court date is the defendant's failure to do something, and then this son of a bitch just told us that he thinks the consequences are going to be devastating and should be devastating for us, right? Not consequences for them and not a failure on their part to inform, but yet a failure for us to show up and consequences that will be devastating put on us. This is what they're telling us.
could be really, really a big problem for people. But then it all comes down to the question of notice: is do they get notice of?
Yes, and just throw that out there like we're lying. You know what I'm saying? You gotta stick that in there. Stick some doubt in the situation.
That is getting entered into the system.
News 4 Tucson asked court officials that very question last week, but have not yet received an answer to the question. Granted, the courts were closed Monday for Labor Day.
Man, I just love the journalistic fortitude of these people. You want to know if the defendants and the people that need to get notice are getting their notices, and you go ask the courts. There's only one party of those two that won't be able to tell you, and that's the courts, you fucking
We reached out to
idiot.
Judge Sergio, who sent us a statement saying, quote, "I met with the Pima County Justice Court's presiding judge. The issue has been addressed and resolved."
So they looked at each other, shrugged their shoulders, and said, fuck it.
I do not have any additional comment. Now we're going to continue digging into this issue to see what the impacts may be and to see what sort of resolution was reached per the judge's statement. We'll keep you updated. We're live from Pima County Justice Court tonight. Cora Snylander, News 4 Tucson.
Well, if you were ever wondering if you missed a court date or if they just didn't to give you notice of it, it's probably the latter. I mean, judging by this. And that was only 7 months ago. Okay, change the subject. Here's what I'm talking about. Okay, so you all remember how my theory about the courts always having two cases or making sure you have an open case or splitting your cases in between two courts like Justice Court and regular court. Okay, look at Mr. Meyer's digital record. He's got two case numbers ending in 1060 and 1454. But of the 1454, he's got two of those. Okay, so you click on it, and then on the 1061, and wouldn't you know it, his name's on there twice. Lane Jeffrey Myers, Lane Jeffrey, right? What the fuck is that all about? Well, I don't know. It's got all his charges on there from the original one, so maybe if they want to accidentally make a mistake on accidentally, then they can just, say that they looked at this instead of what they were supposed to be looking at, like, an existing one that's up to date. I don't know. But anyway, let's go to the one that is up to date. Well, his name is on there once for each case. Now he's got his name on there 3 times. So 2 for the... Do you see what's going on here? Like, there's... Either way, no matter what, there's going to be 2 of something. Either the cases or the charges or... Dude, this is fucking crazy. Okay, but just hang with me now. We're not done. As you can tell, this is an online thing, so the document where it's blue is what you can click on, and where it's not, you can't. You know what I'm saying? Okay, so let's go down further. Again, this is proof, absolute 100% proof, positive proof, that these motherfuckers are doing it for the theatrics and for the sheer entertainment value. They're not doing this based on law, because if so, all the aggravated harassments would have to disappear as a matter of law. I started making this video like 3 days ago, but I just slid this part in here because I just read it right now. So here we go. Okay, motion to dismiss the aggravated harassment. Although the Arizona Court of Appeals previously held the harassment statute, ARS 132921, was constitutional in State v. Brown, the ruling involved an older version of this statute no longer in effect. The legislature modified harassment by removing the requirement of intent. There is no decision by the Arizona Court of Appeals upholding the current statute. In fact, the legislature appears to acknowledge... whatever, it cuts off, but then it picks up. It says state can arbitrarily decide to prosecute because the intent of the individual has no bearing on the case. At any time, any public employee is annoyed or gets their feelings hurt or is over criticized, they can claim harassment and demand prosecution under this. And there's no unacceptable application of harassment. This court must render it vague. Now that's true, because see, Lane is looking out for everybody else, right? And it's true, that is absolutely true. Okay, for this to fit legally, Lane Myers would have had to have a conviction against that victim, Shannon Walker, previously, and then also been under protective order and have an active protective order, and then violated that protective order by making contact with her. That's the only way to get to aggravated anything, or aggravated harassment, felony 5. He doesn't have a previous conviction. He can't possibly have that charge. Now, it is overbroad, yes. It's gonna sound, I'm gonna sound like I'm repeating myself, but these are really 4 days apart, both of these little But as a matter
clips.
of fact, then yes, they're looking at the facts or whatever, or, oh, this one didn't fit because he didn't say this at the right time, or, blah, blah, blah. The dates didn't match up. Dude, the reason that aggravated ones cannot be there is because he does not have a conviction for any pre-existing, any violent crime against that victim or fake victim, Shannon Walker. He would have to have a conviction against Shannon Walker for any of those to exist. And since he doesn't, none of them can exist. But they left 2 of them up there. And oh my gosh, how crazy. They left 2, right? Okay, maybe I'm tripping with the whole 2 thing, but let's go down and see what the first thing we can click on to get out of the the case document and the case information, right? So this is his summons for. Well, anyway, my whole theory is based upon him. Is what they do to get you and keep you in jail. The courts. Now, the courts are the ones that do this 2 theory, or do the Tucson 2, or whatever you want to call it. They have to have a second everything so they can fuck you with it. You know what I mean? It's the only power they have, right? So this is the summons, right? And the first case number is the 0601, right? So, and then the second case that they have is the 1514 or whatever it is, which they show 2 of on his electronic thing, right? So this is the 1060. This is the second case number ending in 1454. Remember, it's the theory of the courts, right? So the courts, they're not the enforcement mechanism, right? Like they always say, but they are what they are. They do create the documents that get you in there and keep you in there. So your bond hearing would be one, and then also too how he got in there. He didn't get arrested. The grand jury basically put him in there, right? So by my theory, there would be 2 documents for the grand jury and 2 for the bond hearing. Going with that same theory, there would be two different records for arrest, right? But we all know there's like 4. You know what I'm saying? The police do that shit all the time. But since he didn't get arrested, that means there would be 2 grand jury documents. Like I showed you, the original arrest, the one that's ending in 060 or whatever, was the original one. This one, 1454, is the one that's doubled, where I first showed you earlier, right? So that's the one that should have the 2 bond hearings and the 2. This one right here, see, 1454 is doubled. So that's the one that should have bond hearings and the grand jury doubled. Oh my gosh, what a coinky dink. It's 2 for the bond hearing, okay? Now, let's go and see the other documents. That's right. 2. It's like a bad dream. What the fuck? Both of these are grand jury whatevers, right? Because they're not the grand jury transcripts, but the grand jury something. For Mr. Myers' grand jury thing, this comes out on page 8 of another judge's minute entry for April 1st. Court reporter, the correct for Mr. Myers, the correct case number for Mr. Myers, but his name's on it nowhere. Luis Francisco Gamboa is the name on it. And then the bottom reads like this. So Mr. Myers' name is, everybody else has their name on this minute entry except Mr. Myers is a case number instead of a name. And then it literally says it is not appropriate because the defendant was in custody and being held without bond. So nowhere on this document does it say Mr. Myers' name, but it has the correct case number. But it says on Friday, March 28th, 2025, the state stated that the defendant was indicted on direct indictment and requested that the summons with booking. That was not appropriate as the defendant was not in custody. As the defendant was in custody being held without bond. The state asks that a notice of supervising indictment issue returnable on Friday, April 4th, 1 p.m. in the Pima County Superior Court. 2:52 p.m. There is no further business to be proceeded to the court. That's just weird. His name's not on there. It's just a bunch of other people's names. I fucked a word up. It was supervening, not supervising. It does list names because it says defendant's name, Luis Francisco Gamboa, $15,000. So it does have names on there, but not Lane Myers' name, but it's in his file with his case number on it. And now for the second one. Okay, I don't know if you remember the videos a couple of videos ago, but I made one about the stamps, about the Gary Harrison stamp, right? They had a administrative order to keep all of the Gary Harrison stamps and authenticating name, like to keep using the name. But now they have the new guy, Guillermo or whatever, so they have his authenticating stamps. See, this is my theory of twos. They need two of everything so they can contradict each other. They have to have, if they have one authenticating stamp, they have to have another, which they have now. They both have authenticating name stamps. Okay, they are most certainly going to try to play off that whenever they get their back into a corner. But here's another thing too. Look at this. It says that his case number, it doesn't say his name, it just says his case is assigned to a different judge now. So now there's two different judges other than Tracy Miller or whatever, but now there's two different judges, assigned judges. Why? Remember that. Okay, so I'm going to show you the part where Mr. Myers objects to the Deborah Moore, or whatever, the Deborah Moore objection, I'm going to call it. I'm going to show you the part where he objects, and then as soon as he gets done objecting, I'm going to cut it off, and then when the judge starts talking, I'm going to cut it off immediately before you hear the judge. And I just want you to think, if you were a judge, what would you say? Or like, what would be your reaction to Mr. Myers' objection? Like he says, this isn't Deborah Moore. Where is this name on the petition? How do you think the judge should react? Just think about that for a little bit, and the sound will come back on.
Sir, it's not on here.
What's the objection?
This is not on here. These phone calls were not mad. These were not on the petition. Nothing about other people calling her are on this petition as an act leading to a harassment. This is all going off the rails. You're just, show me Deborah Moore on the petition. Show me the name Deborah Moore on the petition.
I can't show you, Lane, I'm sorry, but 5 months in the future, I can show you that very same name on a grand jury document with your case number on it, but your name not anywhere. Like, for example, I would have turned to, what's her name, Shannon Walker, and been like, what does Deborah Moore have to do with this? You know what I mean? Or what's the significance of this? Why isn't it on a petition? You know what I'm saying? Instead, dude, this fool's his ultimate reasoning is, it is a phone call, and the petition does mention phone calls. But he says something before that that's even more telling, because what he did say should have been first, but he first says...
The name Deborah Moore on the petition.
Mr. Myers, what I'm hearing you say is you're objecting that the evidence is beyond the scope of the petition.
Of course. It's not even on... Who's Deborah Moore?
You're interrupting me. A couple things. You seem like you're getting angry. Your tone of voice is changing. It makes it hard for me to pay attention when that's going on, so I'll ask you to lower your voice. Second, in my opinion, this is all within the time frame and the scope, and the petition does mention getting phone calls, so I think this falls within the scope of the petition. Go ahead and play the objection's overruled. Go ahead and play.
See, now notice Matt Walker's body language. It's kind of intense in the beginning, because right there is when Mr. Myers throws the paper down, and he's at the edge of his seat. Matt Walker is. Now watch as the judge says watch Matt get more comfortable and ease back as the judge says, couple things, seems like you're getting more angry. And the more the judge talks shit, the more comfortable Matt becomes.
Name Deborah Moore on the petition.
Mr. Myers, what I'm hearing you say is you're objecting that the evidence is beyond the scope of the petition.
Of course. It's not even on... Who's Deborah Moore?
You're interrupting me. A couple things. You seem like you're getting angry. Your tone of voice is changing. It makes it hard for me to pay attention when that's going on, so I'll ask you to lower your voice. Second, in my opinion, this is all within the time frame and the scope and the petition.
Oh, shut the hell up and explain to us why the person who made the damning harassing phone call or whatever to Shannon Walker on her Zoom thing or whatever, why that person's name showed up 5 months later in Mr. Myers' grand jury document as a court reporter. Explain that. He spends like a minute trying to paint a picture of the situation, including Mr. Myers' facial features, when he could have just put it on videotape. And absolutely no time questioning who and what and why Deborah Moore is a part of whatever. You know what I mean? Well, since the judge didn't point out where Deborah Moore's name was on the petition, and now in this grand jury piece of paper thing with the same case number that has attached to Lane Myers on it, what about that, Griffin, my boy? All right, time to shift gears and slide into slippery Matt Walker's, what I think his role Sorry, it's not the transcript. It just says grand jury. The grand jury transcript, it says, came on 4/10/2025. These, what I just showed you was on 4/1, so April 1st, 2025. Maybe it's an April Fool's joke. So he was arraigned on March 14th for all these harassment charges and whatever. And then he's got grand jury documents that say April 1st, but really were on March 28th. And then now he's got a grand jury transcript cover sheet on April 10th. How did he get indicted? How did he have an arraignment without an indictment, right? Then how did you convene a grand jury after he was arrested, after he was arraigned, set out on bond, and then rearrested? Then you get a grand jury, and not even that, just a cover sheet months later. I don't understand, or something. I don't know, but these are the two. Anyways, I don't know, man. Okay, now hear this guy out. So Lane's trying to make a record here, and he's saying something about Matt Walker, the prosecutor at the time, and Matt Walker tries to get him to shut up twice. And the judge, I've never heard a judge say this to Mr. Myers or for Mr. Myers, but the judge says, "Let him finish." Now, 1,000 times I've heard a judge tell Mr. Myers to shut up and let the person finish. Never the other way around. But the judge lets him go on this one, and I believe that this is the most important time that he got to finish what he was saying, I think.
Job. He wants to take public.
This is a public service.
We know that I'm suing the council for booing at the meeting, and this is what this is all about. This is Matt Walker's last chance to save the city of Tucson and his job. He wants to take public tax money, but not face public scrutiny. That's called the opposite of a public servant. That's a thief of taxpayer dollars. That's a controlling. Let's control you with the law. Let's take our money from the very same people we took an oath to protect and serve, and let's do anything. Hey, Your Honor, would this be? Can we deal with this now? All right. So Matt Walker, the state, he has a 56-minute presentation for the prosecuting attorneys union, where I'm gonna, and this might be admissible evidence. Okay, so on the so
that little pause right there, he said on the so that's because he couldn't believe he said that either. Like, he was in disbelief.
On the so in my research, so Matt Walker, the state, he has a podcast for continuing education. That's listed on the Union of Prosecuting Attorneys or something, and what is it, CPAP or APAP? Right, okay. Where in that 56-minute presentation, he gives a presentation on how prosecutors can weaponize the disclosure system to protect the state from unlawful, like if they unlawfully arrest somebody. This man gives a 56-minute video on the internet of how to manipulate the disclosure system. It's called Disclosure, from a shield to a sword, right? So this man has a 56-minute video explaining how to go against, like, not let the defendant to use disclosure. It's called, you know what I'm saying, making the case stale. My wife, until a few days ago, it doesn't matter. Anyways, so just like his wife, it's same thing, right? I guess our wives are part of this case now. And so public employees. But anyways, and this I believe is relevant. Because if we take the facts of this case and we can see the pattern of disclosure going on in this case where I've turned over mine, and then this man has a 56-minute presentation for other state attorneys saying, this is how you manipulate defendants' rights. This is how you protect the state from getting caught manipulating the defendant's disclosure. It's called turning it from a shield, because normally the state has the burden of proof, sir. Normally the state has the burden of proof to present their evidence in an ethical way. This man, Matt Walker, has a whole video for the state how to be unethical with disclosure. And it's disseminated for money on the internet, and you could get credits for your continuing education. on a video, and if you take the video, sir, it's exactly what's going on here. They're manipulating the evidence. They're hiding the arresting officer. They're failing to disclose until a court order. This man is an embarrassment, and I already knew all this was going to come out. So it's a pattern. This man makes a video for the whole world to say, I'm Matt Walker, and this is how you screw defendants over using disclosure.
Artist. I talk till I'm red in my face with strain polyps. I'll rock till I'm out of my range and raise octaves. I play through the pain and remain conscious, refraining from commenting on the lame compliments and the petty criticisms from those who ain't accomplished even 1/5 of some of this shit I made progress with. I'm leaving naysayers stumped like rainforests. After years of pulling rabbit ears out my pants pockets, I'm not revealing any tricks of the trade. It's just there ain't no magic in the breakdown, baby. After they make almost see what I find out my life, and I started to give them a look. None of them give it a glance, and I guess that I'm sitting in the middle of an unread book.
Want to hear what it sounds like when a regular person tries to get an injunction against harassment? Well, I don't know what that sounds like, but here's what it sounds like when Lane Myers does. Okay, so yeah, everybody's talking about this one as it's valid or whatever, but I don't think it is because, well, first of all, Shannon got the Threat Management, Terroristic Assessment, Homeland Security Department to serve him, right? But cops don't serve injunctions against harassment. For example, the lady who gave her the injunction against harassment, the judge, had this to say.
Based on the pleadings, the court finds reasonable cause to believe the defendant has harassed it by committing one or more acts of harassment, and therefore it's ordered granting the injunction against harassment and orders that the defendant will have no contact with the plaintiff, with the protected persons listed in the injunction against harassment, or with the protected locations. The court further orders regarding this order of protection. A constable will not serve this for you. So it will go into effect when he is served, but you are going to need to personally have that served on him, either hire a process server, take it through the chef, whichever you feel. Have that served on him, either hire a process server, take it through the chef, whichever you feel.
And this is after she already had those same goons following him. Like she literally says that she had the goons follow him. She didn't use the word goons, but all the rest of the words she said.
Connect the University of Arizona Police Department and our threat management team who has been following this gentleman. So it's now not only affecting me, but my people I work with. And
did she do that? Hire a process server or take it to the sheriff? No, she got the campus police department's threat management, risk assessment, homeland security sergeant, David Hill, who has just recently shot a guy, to call Lane and say, see, the process server that he got served with was another person. The process server drove to his house, walked up to the door, and dropped it off, and then Lane walked him back, told him to get off his property, then walked with him, picked his brain, and made friends with him, right? Okay, a cop has no business calling you if he has your address. Not only that, but the first phone call that should have never happened, Lane even said, come drop it off to me. But the cop was trying to meet him somewhere, and he was like, I'm not going to meet you anywhere. Come drop it off. You know where I live. And on top of that, whenever he called the judge at Superior Court to get his own injunction, that judge knew about the cop trying to serve Lane already. How is that possible?
States you received a call about someone trying to serve you with an injunction against harassment.
No, wrong. They called me and said they wanted to talk to me and meet with me. The injunction, they said they didn't say why. I asked them why. They said they wouldn't. Listen, they called me, this guy, not they, David Hill, called me, and I started asking him questions why he's calling me, and he wouldn't tell me. And he said, that's okay. You don't want to talk to me? I'll find you and catch up with you. I said, okay, that sounds like a threat. So I called the FBI, who I've been working with. I have a case going with the FBI against the city of Tucson. I immediately called the FBI, and she looked into it. The agent, I'm not going to say her name right now because this is being recorded, but you can verify all this.
Fine, I don't need it.
No, I'm saying, but it's all verifiable. And so I'm not making false statements under oath. And so she told me, listen, you can ignore him. You can tell him to leave you alone. He has no legal reason to be contacting you. That's if he has an injunction for harassment, then he can.
I'm gonna let you know something. There is a legal reason for him to be contacting you. Here's the deal, though. Nobody can tell you who the injunction. If there is an injunction filed against you, they can't give you the name of the person until it's been served.
What is the legal reason that Officer David Hill can contact me, ma'am?
I'm assuming he's trying to serve you with an injunction against harassment.
Why would you assume that when I already articulated to the court under oath that I went and verified with both courts that there is no injunction against me?
And I'm telling you, sir, that you are likely incorrect.
Didn't you just state for the record that I could go to the court and accept service? Well, I went yesterday.
Listen to the way she says this. She says, you can go to the courthouse and accept service. Like, come on, dude. Double speaking like a mug, dude. Because of course you can go there and accept service, but you could get arrested, or in fact, more accurately, I know that you're going to get arrested. My fingers are crossed behind my back, bitch.
And I have a YouTube video on my channel. Okay, so you
can come to the court and accept service of an injunction against harassment.
How do you accept service of an injunction harassment that doesn't exist? Because I came to the court to accept service, ma'am. You're gaslighting me, ma'am.
That one does exist.
I came to the court.
In no universe should that ever happen. There's no way if you randomly call a judge and try to get an injunction against harassment, there's no way that judge should know anything about you, especially if you have one pending and waiting for you. And on top of that, this is the phone call. The next day when he went down there, that's the U-turn. That's the U-turn day. When he drove back home after serving himself and drove by that building, that's when he violated the injunction. That's why this is so controversial, I guess you could say. She shouldn't have any information. He's trying to get an injunction of harassment against somebody. She shouldn't have any information. Before I show you, I want to show you something else. So you know how police have their complaints or whatever, and you can't really look at a cop's like personnel file or whatever, like an individual cop, like about their, the complaints they have, the discipline they received, and all that shit. Well, judges keep theirs public, right? And so it's like their reprimands, and there's like 4 or 5 categories of shit that, like, disciplinary type shit for judges. You want to see? You want me to show you what theirs looks like for Pima County? It's just what you would think. Just what you would think. Removal 0, suspension 0, censure 0, reprimand 0, other public disposition 0, dismissal with comment 0, all dismissal 0. Right? Perfect score, guys. So now I told you about, well, if you guys watched my like earlier videos or whatever, God forbid, I mean, because they're all shitty. But anyway, I have this theory, not a theory, but it's an observation that whenever the judges want somebody to, whenever they want to railroad somebody, right? They'll start sentencing. Well, first of all, they'll do like what Griffin did, and they'll start talking about you and your behavior when they don't need to be, and when there's nothing really going wrong. And most importantly, they'll start every sentence with your name, like Mr. Myers, please, and then they'll tell you to do something that's behavioral based, like sit down. Like, there's nothing wrong with standing up. You can stand up in court. Lawyers do it all the time. But when a judge says, hey, Mr. Myers, sit down, it not only acknowledges that that's who you're talking to and that's who is disobeying whatever you're told to do, but it's something you're told to do when you don't need to do it. And the only reason to do that is to piss somebody off, or to get the audio, or to get it on film or whatever, to get a record of it. You know what I mean? There's no reason to tell somebody to sit down unless they're doing jumping jacks or something, in which case that's just weird and you would say stop doing jumping jacks. But so when they tell you, when a judge starts either name or starts a sentence with your name and then gives you a sit down or whatever, a command like that, then I think they're doing it for the audio, and I'm going to show you why I think this, because it's just like what cops do when they get a bunch of footage together and then so they can show it to the governor and say, oh, this is a huge problem, we need to bring this up and make a law. You know what I mean? Cops do the same thing, and I think district attorneys do this for, and judges help out with the same process whenever they try to get a Supreme Court rule changed, because judges in courtrooms don't need Congress to make a law, or a law that will affect their world. The only laws that they care about are ones that control them, which in the courts is the Supreme Court rules, you know what I mean? Which they can change by simply writing some shit down on the internet on a PDF file and sending it to them. But I think all the behavior that they've been stoking or creating or poking at Mr. Myers and all the footage they got, I think they're just going to add that into a little attachment file and send it along with Matt Walker's petition. That's what I think is happening, because every single judge, other than Riojas, which, by the way, Riojas is the only one out of them that said, let let Lane finish, and then that ruled in his favor when he was right. You know what I mean? It was the right thing to do. It wasn't just because he picked a side and liked him. He didn't. The first thing he did was say, "You're a piece of shit judge. You're a fake ass scam ass judge." So it's not like Riojas had a thing for him from the beginning. You know what I mean? But he is the only one, and the thing is that's even more telling is that Riojas is the only one that doesn't spend time around the rest of these on a daily basis. Riojas was in retirement. He's not friends with any of these fuckers, right? So that's telling right there, you know? So I'm just going to spill the beans about why I think this is all orchestrated the way it is because Doug Metcalf, just like Matt Walker, who has a petition to change Rule 122H because he's been wholly embarrassed by his own performances, and just so happens that other people seen it, that he doesn't think that it warrants him to change his morals and ethics and work values and maybe change his schedule, maybe just do better in life. He doesn't think that any of that has to do with anything. He thinks it's the rule that's the problem, right? The rule that we all like. But anyways, Doug Metcalf also has something that he wants to change. And also, Lane Myers has a very, very strong hand in the game. Because Doug is trying to change to special action. And if anybody is a candidate for a special action right now, it's Lane Myers. But the problem is, to get his rule change the way he wants, it doesn't involve Lane Myers coming out on top, right? He would have to re-railroad him, right, to prove a point. But I don't know, it's kind of complicated. But Doug and Matt both have a reason to have Lane Myers in jail awaiting trial. It's weird. Just weird how that happens. Just a real quick demonstration here about some stuff. Okay, so I took the Stacey Jane recordings, right? The ones where the judge is real kind of quiet. And what I wanted to do was take a length of a clip and then kind of chop it up to make it seem like what they would do, what I think they would do, and bring to show to like some Supreme Court people and be like, oh, look, this guy's being disruptive when really he's not. You know what I mean? So here's a little story that I made up that they might tell possibly about these little clips. And then I'll play them without them uncut. You know what I mean? So here's a little story. Mr. Myers was unlawfully recording her, and whenever he kept cutting her off, and whenever she tried to bring it up, then he yelled at her. Also, he recorded Miss Jane with no permission. Yes, hello, Magoo, yes. Well, Mr. Myers was live streaming the whole time, being very vocal about it. He made many disparaging comments against Miss Jane, and he was just basically irate the whole time, and at one point made the judge get up out of his chair and yell at the top of his lungs, and he decided to amend the complaint, Mr. Myers did, yes. Did I mention violently live streaming and recording this young woman without her permission?
Mr. Myers did record that September 12th communication without my knowledge or permission.
You'll get the opportunity. You don't have to interrupt the counsel.
On October 2nd, 2024, Mr. Myers live streamed a
That's
YouTube
not on the
video.
petition, Your Honor. This woman is not capable of following rules, it appears.
Your Honor, Mr. Myers has now made multiple disparaging comments about me during this hearing.
Let her testify, sir. Would you please do that?
Can you please let this woman...
She can tell me of her contacts with you.
She cannot...
Harassing
You
contacts.
have to do that ahead of time.
Do you wish to do that?
I move to amend the petition to include additional harassing contacts and to request expanded scope of the protective order.
Sir!
Just try to restrain yourself for a moment. You're the one who's asking for the amendment.
Right? It sounded like all that happened. You know what I mean? And he even said, you're the one that's asking for the amendment. But he wasn't, though, because I cut that part out. Now, listen to the whole audio without any of it cut. What's really going on is there's only two things she can talk about. The two dates she wrote in the petition, and then she's... And it's an injunction for harassment hearing, not a protective order. So keep that in mind.
On October 2nd, 2024, Mr. Myers live streamed a
That's
YouTube
not on the
video.
petition, Your Honor. There's the two dates on the petition are September 12th and October 4th. There's nothing about a live stream on October 2nd on this petition. This woman is not capable of following rules, it appears. And she's an attorney with the Arizona Bar Association.
Your Honor, Mr. Myers has now made multiple disparaging comments about me during this hearing. And
saying she's a member of the bar?
Okay, so let her testify, sir. Would you please do that?
Can you please let this woman follow the rules?
She can tell me of her contacts with you.
She cannot talk about anything that's not in this petition unless she wants to amend the petition and in front of you.
I have, fine, then you can do that.
Nothing to do with the petition.
Additional contacts
Oh,
are
don't interrupt.
protection order petition to include additional harassing
You have
contacts.
to do that ahead of time.
Do you wish to do that?
I move to amend the petition to include additional harassing contacts and to request expanded scope of the protective order.
Okay, I think we're going to have to file an amendment.
Okay.
And then we'll.
So why did she bring us here? This is.
Sir! Just try to restrain yourself for a moment. You're the one who's asking for the amendment. You do need to ask for the amendment. If you want to ask for additional relief and ask for include additional acts, then it is in fact the title. I have notice of that and to respond accordingly. So you will need to go to. She has a form that you can fill out. We will continue this hearing.
You can't continue without hearing these incidents here. We're here. She can file an amended complaint after this. You can't stop the hearing in the middle of it and amend it.
You see how they can take it and make it seem like that's what... Now, for example, what actually happened, here the judge tells you right here, he says Mr. Myers is right about the amendment and she can't do it.
Appropriate, I'm happy to testify to the content of the existing petition and
Okay.
then move to
We'll
amend.
proceed that way. I believe he may be correct in terms of the amendment issue.
He said, I believe he may be correct in terms of the amendment issue, like saying you can't do it right now. You have to wait till this is over and then amend it, right? But when in the first one, if you clip it up right, you can make it sound like anything. You know what I mean? So, like, Your Honor, Mr. Myers has made many disparaging comments. All he said was she's a member of the bar and she's a professor. He literally just stated her title and her educational background, and she said that was disparaging. But if you clip it up right, it sounds like he was talking shit. And I mean, in all reality, he won because they quashed the petition, and he won basically. He got what he wanted. You know what I mean? So, because it probably, and see, it doesn't matter what they show their judge buddies as long as it's, you know what I mean. It meets half of what they say. The pretentious motherfuckers will just agree with it. You know what I mean? They don't care if it's real or not.